Welcome to Module 8, Federal Rule of Evidence 408. We are in the midst of studying 5 specialized rules of relevance, which I call the SAPI rules, rules that ban the use of particular pieces of evidence if offered for particular purposes. Rule 408 has 3 main components to it. First, prohibited uses of compromise evidence. Evidence of a compromise or an attempt to compromise, namely a settlement, are inadmissible if offered to prove liability for or the invalidity of a claim where there's a dispute, or to impeach. Second, Rule 408 discusses several permissible uses. The rule does not require the exclusion of compromise evidence when it's offered for purposes that are not explicitly prohibited. And the rule contains some examples, such as proving bias or prejudice of a witness, negating a contention of undue delay, or proving an effort to obstruct criminal investigations. The third point is, even if compromise evidence survives Rule 408, it's offered for a valid other purpose, it still has to be analyzed in light of Rule 403. Note that Rule 408 only applies in civil cases, not criminal cases. And also be mindful of the rationales for this rule. This evidence has very limited probative value if offered to prove liability or invalidity. Why? Because there might be reasons other than liability or invalidity for a person to enter settlement negotiations. Perhaps the party simply wants to maintain peace and get the issue resolved as quickly and amicably as possible. Second, this evidence has a high risk of prejudice. After all, if a jury were to hear about certain statements made during settlement negotiations or the fact of a settlement negotiation, it might infer liability. It might infer that the party wanted to sweep the case under the rug. Lastly, there are strong public policy reasons for this rule. In essence, we want to encourage compromise settlements in order to ease the pressure on our litigation dockets. Now, 4 points are worth clarifying at this stage. First, the rule relates both to attempts to compromise and completed compromises. Attempts to compromise often come up. Let's say Adam has sued a major hamburger chain alleging food poisoning. Adam and the hamburger chain enter into compromise negotiations. However, they don't reach an accord, and the case proceeds to trial. Suppose Adam seeks to introduce certain statements that the hamburger company made during those settlement negotiations into evidence at trial. Rule 408 would say that that is banned if it's offered to prove liability. Why? Because it relates to an attempt to compromise that failed to culminate in a settlement. When, however, might evidence of a completed compromise be an issue? It usually comes up in a case involving multiple litigants. So let's say that not only has Adam sued the hamburger company alleging food poisoning, but also that Brenda has done so. Let's further suppose that Adam has settled and earned a nice tidy sum from the hamburger company. Brenda, however, has chosen to proceed to trial, and she wants to introduce evidence of Adam's completed compromise with the hamburger company in order to show that the hamburger company is potentially liable in her case. Rule 408 would ban the introduction of that evidence if offered to prove liability. Second, there must be a claim. What is a claim for purposes of 408? Well, obviously a lawsuit constitutes a claim. However, some courts have found that even informal demands might constitute a claim for 408 purposes. So even pre-lawsuit discussions might conceivably be covered under Rule 408. Third, note that this rule covers statements or conduct during compromise negotiations, as well as the use of statements to impeach or contradict something that occurred at trial. Fourth, be mindful of the fact that the permissible purposes listed in Rule 408 are just illustrative. They're not exhaustive. As in Rule 407, the list is potentially infinite. If you can come up with a reason for introducing this evidence other than the prohibited purposes, then you will survive Rule 408 to face Rule 403.